Welcome, everyone. We're going to be starting in about 2 minutes. We have live captioning for today's session, but you may need to activate it in order to see it. You should see an option to show subtitles in the bottom toolbar. So you can go ahead and click on the bottom toolbar and select the option to show subtitles. If you prefer, we also have stream text available. We're going to put that in the chat right now. You're also able to hide non-video participants if you would prefer that. Right-click on any participant's window and select Hide Non-Video Participants. If you need any help during this session, please let us know in the chat. Welcome to How to Create Change in Police Services, Transparency, Accountability, and Reform.
Good afternoon. On behalf of the National Association for Rights Protection and Advocacy, also abbreviated as Narpa, I am pleased to welcome you to the 4th installment of our 2021 webinar series. Narpa's mission is to support people with psychiatric diagnoses to exercise their legal and human rights, with the goals of abolishing forced treatment and ensuring autonomy, dignity, and choice. My name is Kwamina Blankson, and I am the president of Narpa's board of directors. My pronouns are he, him, his. I am a 47-year-old West African wearing dark-rimmed glasses, a gray cap, and a gray V-neck t-shirt. Today's presentation is entitled, How to Create Change in Police Services, Transparency, Accountability, and Reform. This is the 4th in a series of 5 webinars that further Narpa's goal of supporting the legal and human rights of people with psychiatric diagnoses. First, thank you to the folks at Disability Rights North Carolina for hosting this webinar. As I've stated so often, Narpa feels fortunate anytime we have an opportunity to collaborate with protection and advocacy agencies throughout the United States. Thanks also to all of you who registered to participate in one or all 5 of the webinars in our fall series. Please take advantage of Narpa's YouTube channel, where you will be able to watch all 5 webinars once they have been uploaded. As president of the board of directors, I am honored to have a small part in the success of a webinar series that was originally conceived in lieu of the in-person conferences to which we had grown accustomed over the years, and which, because of the pandemic, we no longer take for granted. We miss being able to meet face-to-face and have opportunities to connect with our allies and co-conspirators. Last, I regret to share the sad news that a beloved member of our board, Darby Penny, passed away just a few days ago. Darby was truly a fixture in the advocacy community of the Northeast as well as nationwide. She may be most well known by you as the co-author of the book, The Lives They Left Behind. But she was so much more than that. And we invite you to stay tuned for a memorial tribute that Narpa will announce in the coming weeks. And with that, it is my pleasure to introduce Virginia Knowlton Marcus, Executive Director of Disability Rights North Carolina.
Thank you, Kwamina. My name is Virginia Knowlton Marcus. I'm the CEO of Disability Rights North Carolina. My pronouns are she and her. I am a petite middle-aged white woman. I have short brown hair with silver highlights. I'm wearing a black sweater that has small gold flowers embroidered around the collar. And my background is the green and white Disability Rights North Carolina logo with its stylized pine branch. DRNC is very pleased to collaborate with Narpa, the esteemed national advocacy group of mental health survivors and allies fighting for our essential human rights, to help produce their online series. DRNC is particularly honored to be sponsoring this Narpa webinar in honor of Darby Penny, focused on the critically important topic of advocacy strategies for reforming police intervention and interactions with people who have mental health disabilities. DRNC recently sponsored a similar online panel focused on the Mid-Atlantic region of the US. Today, we will learn from advocates in the Greater Toronto, Canada region. We are fortunate to have terrific expert speakers whom we're very eager to hear from. They are prepared to introduce themselves. So let's quickly turn the spotlight over to Anita, Jennifer, and Maya. Welcome.
Thank you so much, Virginia, and good afternoon, everyone. While we meet today on a virtual platform, I would like to begin by acknowledging the Indigenous peoples of all of the lands that we are on today. We do this to reaffirm our commitment and responsibility in improving relationships between nations and to improving our own understanding of local Indigenous peoples and their cultures. As we're joining you today from Ontario, we acknowledge the land we are participating from is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. With that, I will now introduce myself. My name is Maya Kotob. I use she, her pronouns. I have light brown skin and I'm an Arab woman. I wear a hijab or a headscarf. My hijab is light pink and I have on a black top. I'm at a desk in my living room. In the background is a white couch and a mid-sized rug, and also visible is a dark gray rocking chair and the door to the room. I'm a lawyer working at Anita Szigeti Advocates in Toronto, Ontario. It's really lovely to be here, and thank you so much for joining us for this important discussion. I'm now going to pass the virtual microphone to Jen and Anita for their introductions.
Go ahead, Anita.
Hi, I'm Anita Szigeti. I am a middle-aged, very voluptuous white woman with reddish brown curly hair that's tied up in a bun. I'm wearing, well, I was wearing, and now I'm wearing again, purple cat eye shaped glasses, a black dress with fuchsia colored flowers, and a red bolero jacket. I'm sitting at my laptop on my couch. Behind me is a red wall and my gecko bananas in his terrarium on my right, and about half of a giant stuffed blue jay, because we're baseball fans here in Toronto, on my left. I'm a lawyer. I have a law firm with 7 staff in Toronto called Anita Szigeti Advocates. I act exclusively for clients in psychiatric detention in civil or forensic hospitals when they're brought in through criminal justice. I also represent the Empowerment Council in some systemic litigation, including at the Supreme Court of Canada level and at Inquest. I just want to pause for a minute before Jennifer introduces herself, and before we start our talk, to pause and remember Darby Penny personally. Darby meant a great deal to me as a mentor and colleague on the Narpa board, and as a friend. Darby chaired a defund police committee of Narpa, and we have a defund police statement. Our committee was called ABLE, ABLE, an acronym for Alternatives to Bad Law Enforcement. She taught me a lot while we worked together on these issues of policing contact with persons with psychiatric histories. And our panel today is dedicated to the great Darby Penny in her honor. Jennifer.
Thanks. It's an interesting exercise to describe yourself. Am I on camera? I'm not showing up on my own screen. Can you see me?
Yes,
I am?
you are.
Okay, great. So I'm a gray-haired white woman, kind of pinkish actually, who'll be eligible for senior citizens discount soon. I'm wearing cat's eye glasses with sparkly bits on the edges, which I tend to think sparkly would sound like tinkly. Behind me is a wall with a picture of an ocean on it, a greenish colored wall. I'm sitting on a black sofa that hopefully has no laundry slung over the back of it. I'm sorry, there's a disturbance at the front of my house. So I'm going to launch into the talk. So I think that, oh, Maya, do you want to start?
Thank you so much, Jen. And I'm actually going to start by asking you, do you think there needs to be a particular foundation for doing this kind of work that we're talking about today?
I think that any organization that advocates in the mental health arena should have a broad disability rights perspective. And in Canada, perception of disability creates protection under the law as well as actual disability. So you don't have to believe having a psychiatric label creates an actual disability in order to access human rights protections. If seeking to change or replace the police, it's important for people to understand that the mental health system also detains people arbitrarily and uses force with racial bias. The mental health system is not going to right the wrongs of the justice system, although humane and respectful supports can help prevent trouble with the law. And by the way, if I'm speaking too quickly for signers, please indicate whoever you like. A lot of the mental health system also needs to be fixed or replaced with better alternatives. As this is the National Advocacy and Rights Protection Association, I figure the odds are pretty good that we're speaking with rights-oriented people right now. So perhaps this doesn't need saying, but many well-intentioned people calling for mental health workers to replace the police don't think to add that the mental health system also needs more work on being force and coercion free. All the work we're talking about today has been done by a peer advocacy organization with many essential allies. I'm executive director of the Empowerment Council, which is who conducts systemic advocacy in mental health and addictions. I believe that organizations claiming to serve people believed to have mental health issues should be accountable to the people they're supposed to serve. Leadership by psychiatric survivors, also called service users, many terms, must also be meaningful and not tokenism. There are many admirable peer-led initiatives that prove what people can accomplish with the resources to do it. So the Empowerment Council is led by psychiatric survivors and people who identify as having had addiction issues. Our mandate is systemic advocacy. We only have 2.5 staff positions, so we try to concentrate on work that can have the most impact. The Empowerment Council and its forerunner, the Queen Street Patients Council, have been working on changing the police for about 25 years, mostly in Toronto. There's been progress and there's been backsliding. As with all advocacy, it's never done. The idea of reform we're talking about today includes abolition. As with the hospital-based advocacy we do, we have our ideals for which we strive, while also trying to make the conditions that people are experiencing now as good or as least bad as we can manage to get them.
Okay, thank you so much. And what are the partnerships that the Empowerment Council has worked within to change the Toronto Police Service?
Some of our first work with allies in police reform has been the Urban Alliance on Race Relations, us, then the Queen Street Patients Council, and the Toronto Police Service worked together to organize a conference on the alternatives to the use of lethal force by police. That was over 20 years ago. It was the only conference of its kind that had ever been done at the time. And I learned a lot from that experience, mostly from experienced anti-racism activists. We fought for what we wanted. We fell back if we had to, but we kept showing up and talking and pushing. We'd compromised, but we also had lines that couldn't be crossed. For instance, we said we would not exclude anyone we invited because the police objected to them, but we also said that they could invite whoever they wanted. So during the process of the conference organizing, we developed enough trust and sense of each other during the conference organizing that it helped lead to the mental health education of the Toronto Police Service being done by psychiatric survivors rather than mental health professionals. There was an unusually low incidence of Toronto police shooting people in crisis in the years following that education, but it's not really possible to pin that to one cause. More recently, a group combining members of the Black community, the Information and Privacy Office, the Empowerment Council, and the Toronto Police Service have been working on a series of Know Your Rights videos. They're written by the community and produced by the Toronto Police Service. The actors are either police officers or Black youth or committee members. We don't have a link yet. We're still finishing it, but we can send it to Narpa when we do. One video that's in the works now tells people what their rights are in relation to the police on mental health calls. Or more precisely, it tells people when their rights to liberty can be interfered with, which means that if those conditions are not met, then they're free to go, or the police are free to go. At the end, we list services that can be contacted instead of calling the 911 emergency line at all. I just wish that there was many good crisis services as there were police. The other videos tell people about their rights in situations with police that have often unduly focused on people who are Black, like being stopped and questioned. This is still relevant to people who have psychiatric histories, and I'll give you an example later in the presentation about a car stop that resulted in a death.
Okay. And when people are killed by police, what are some things advocates can do in Canada to try to stop it from happening again?
But in Canada, we make quite a bit of use of inquests, which are public inquiries into deaths. The juries at inquests can make recommendations to various bodies, maybe not a good choice of words in the circumstances, institutions, to prevent similar deaths from occurring. And the Empowerment Council regularly has standing at inquests when a person considered to have a mental health issue is killed by police or by the hospital where they were confined. There's been some people who died in restraints as well. So far, we're the only psychiatric survivor organization in Canada doing this kind of systemic advocacy as part of our mandate. I understand that inquests are an option that are less often used in the United States, that grand juries are heavily relied upon instead, which are closed to the public and are controlled by prosecutors. So we're going to talk about how inquests work, and maybe you'll become interested in lobbying against grand juries for more public and balanced accountability. And now over to Anita, who's going to describe inquests.
Thank you so much, Jen. And yeah, Anita, I'm going to turn to you at this point. Can you tell us what is a coroner's inquest in Ontario, Canada?
Thanks. A coroner's inquest examines the circumstances of a death. There are mandatory inquests, such as when someone dies in police custody. This includes all police shooting inquests. Or there's discretionary inquests the coroner may call to examine a systemic issue. The function of the inquest is to make findings of fact about the death to determine what happened, and where appropriate, there is a preventative aspect in recommendations for going forward to prevent future such deaths. The coroner's motto is, "We speak for the dead to protect the living." The inquest's findings cannot lay blame or find legal fault with any party.
And what does an inquest look like? Like, how does it proceed?
The inquest proceeding are held in court, usually presided over by a coroner who is a doctor. Recently, this has changed to allow for lawyers to preside over some inquests that have particular legal issues. There is a jury who will decide the matter and render the verdict. The jury can ask questions throughout the proceeding. The jury must determine how and when the death occurred. They have to answer 5 questions: who died, when, where, how, and by what means. They do not have to, but may make recommendations arising out of the inquest. The recommendations must be practical and geared toward preventing future death in similar circumstances.
And who are the parties to this inquest?
There are 2 kinds of parties to inquests: those with private standing and those who meet the test for standing under the public interest standing test. Private standing parties have to have a direct connection to the deceased or the circumstances of the death. The private standing parties are usually family, and then anyone whose conduct may become the subject of censure or criticism, which is a weird thing because, of course, the jury cannot make any findings of fault or blame any party for their conduct. They can make no findings of guilt in law. In police shooting inquests, the individual officers, police service, and union of officers will generally all have standing and will have different lawyers representing them. The public interest standing test requires that the group applying for standing have a direct interest in the inquest and a unique perspective and special expertise in the issues within the inquest. Public interest interveners are seen as the change makers, looking for broad recommendations for improving systemic issues that may have contributed to the death. Private interest parties involved with the death are generally trying to defend their reputation and maintain the status quo, resisting systemic changes which may imply that there is room for improvement in their existing practices. The law of standing and the Ontario Chief Coroner's approach to standing has evolved over the last 20 years. Back in the late 1990s, you had to be identically situated to the deceased to participate. So for example, when one patient client on a secure psychiatric ward died, the 19 surviving clients on that same unit were granted standing to intervene in the public interest. However, at that time, neither all the other patients or clients within the institution, nor any systemic advocacy organization like the Empowerment Council or Narpa would have gotten standing at the inquest. One of the sort of big gains over the last 20 years that I've been involved with the work is that the coroner's office has undergone a massive transformation to the point that they now proactively reach out to us and invite us to participate in any way we can, including seeking full standing where we are equal parties entitled to cross-examine witnesses, lead our own evidence, and make submissions to the jury, or just to make submissions or offer to present a witness.
Okay, thank you so much. And who defines the scope of the inquest, and why does that matter?
So the tension is between defining the scope of the death inquiry as narrow versus broad. The issue is always what is meant by the circumstances of the death. Police would prefer to keep the scope to the minutes around the incident and the death, or they may want to look at the mental health history of the individual in an effort to show a history of dangerousness or perceived need for involuntary hospitalization and forced treatment. So they want to show that the person was previously detained or forcibly treated, and or that they should have been detained or treated against their will at the time that they were in crisis and police killed them. Public interest interveners want to have a broader look. We want to have a look at what training police have, what alternative crisis responses were or were not available.
Okay, and you mentioned jury recommendations earlier. What recommendations are the parties trying to get, and why?
Survivor groups want to defend against police seeking recommendations to change mental health legislation, to broaden criteria for involuntary committal or certification, or for in favor of what we call community treatment orders. I think in the US, you used to call them involuntary outpatient commitment. Survivor groups may also want to seek recommendations for more services in the community, more choice, more accommodation of self-identified needs for housing, for supports, for education, for employment. We're there to shift the focus away from coercion and the use of force. Police tend to use these inquests to get recommendations or to seek recommendations for more weapons, such as taser on their belt. We are there to defend against that as well.
Right. And as a lawyer who has been involved in many inquests, can you tell us what are some strategic considerations in representing a psychiatric survivor organization at a coroner's inquest?
So there are two main things that I think about when I act as counsel to the Empowerment Council or other advocacy organizations. One, what is our goal in participating in the inquest? Generally, we are there to humanize the person who was killed. We're there to humanize psychiatric survivors. We're there to destigmatize the client population. We're there to fight against and eradicate any presumption of dangerousness or lack of capacity, to educate the jury and the coroner about dangers of forced drugging and detention, to educate the jury and the coroner about what our clients need, to educate about how to de-escalate someone experiencing a crisis, to defend against potential recommendations for more coercion in mental health systems, defend against potential recommendations for more lethal force options, advocate for less lethal alternatives, community-based mobile crisis intervention by people with lived experience, mandatory training to be delivered by survivors geared to de-escalation, direct involvement by survivors in policy and practices throughout all levels of decision-making within policing. And then the second thing is, having identified those goals, how do we then accomplish these goals? So I think the best thing that we do, that you want to do, is come to the inquest with a list of recommendations that at the end of the day, you want the jury to make. You do that by litigating as if it were a trial, getting the facts into evidence to support recommendations we want the jury to make at the end of the inquest, getting that evidence from police and other witnesses called by the coroner and other parties, putting our own witness on the stand, putting recommendations from other inquests to each witness, probing policing witnesses about why previous recommendations have not yet been implemented or not implemented at all, and working collaboratively with the other lawyers, which is sometimes very challenging. There's also a tremendous power in the closing submissions. Generally get given at least about a half an hour to make a closing statement to the jury, summing up everything we've heard. And this is usually a very emotional part of the inquest process that can make the difference between whether you reach the jury to make the recommendations you want or not.
Okay, thank you so much, Anita, for that. And Jen, at this stage, could you take us through the inquest that you've been involved with over the years?
Yeah, and so if you want to put up the slides, I'll start doing that. And I'll also mention that it took a while before coroners trusted that we were credible and practical participants, and that we weren't going to use the inquest to grandstand on matters that weren't related to the facts of the inquest. So when you're part of an inquest, you need to agree not to expand the scope of the inquest, but at the same time, we can push to include witnesses who can present evidence that we argue is within the scope. Racism is one such issue. Okay, you want to take us through slides until we get to Edmund Yu? Next slide. So the first inquest we were involved with was Edmund Yu, who was a Chinese former medical student who was shot by police on a streetcar while holding a small hammer. Some of the recommendations that we got were that crisis resolution training should be part of annual mandatory training for police, and an increase in funding for safe beds and survivor employment initiatives. What didn't work out is we're actually there to oppose getting community treatment orders, but when I wanted to address it as a witness, I was told I couldn't because nobody had brought it up, so it wasn't on the table. And yet, lo and behold, when the recommendations came out, the jury somehow made one for community treatment orders. So that was a lesson. Next slide, please, Maya. So Wayne Williams was shot by police after vandalizing some cars, holding a knife. His family was at the inquest and supported our involvement. The inquest recommendations from Wayne's death led to prioritizing crisis resolution training, such that all uniformed officers in Toronto were trained by a psychiatric survivor panel in 1 year. And at that inquest, when we attempted to address community treatment orders, and again, we're told it wasn't on the table, we said we're not falling for that again, and addressed it and managed to prevent it being recommended. Didn't in the long run save us from getting them, but it possibly helped delay it. Otto Voss was a Hungarian man who died when struck by the officers with batons over 50 times after having caused a minor disturbance. The recommendations coming from the inquest included that there be an enduring structure for affecting the best outcome for psychiatric survivors. So rather than just appearing after people died, we wanted a way to have ongoing input into what the police were doing and how they were doing it. A significant participation by psychiatric survivors were required as part of that, as well as our being able to review all the training the police got in mental health every year. After that, there was a three-part inquest, 3 people who had died: Rael Jardine Douglas, Sylvia Kringadis, and Michael Elligan. They were combined because they were all people who were holding edged weapons. And I guess they wanted to consider how to respond to that particular situation. So we ended up with a lot of inquests recommendations that we had sought, and they included police training, emphasizing verbal de-escalation techniques, and that this be evaluated to assess its practice in the field, so whether it was actually happening. We also suggested that if the police are in situations where someone's holding a weapon and they do what they're taught to do, which is just keep shouting, drop the weapon, they might try something else if that's not having any effect, like, what's wrong? Can we help you? What's going on? Something. Jermaine Carby's inquest, which was actually in Peel, not in Toronto. I was an expert witness rather than our having standing. In his situation, the police pulled a car over. He wasn't even driving. He was a passenger. They reported he had a knife and he had ended up getting shot. At this inquest, for the first time, we're allowed to introduce, to some extent, the idea of race playing a role. We had to call it unconscious bias, but we still were able to get it addressed in terms of what police need to get in training. Next slide. Charlie Mcgilliverry died in a case of mistaken identity when two police officers attempted to arrest him, mistaking him for a man who had allegedly breached his bail conditions. They yelled at him to stop. He didn't stop. He was both hard of hearing, and it wasn't his name that they were calling. So he was, there's a takedown, and he was restrained by police and died during that restraint. That was one of the sadder inquests for us because it felt like we were the only people there at the inquest who cared deeply about what happened. His mother was too traumatized to attend. It was right after another big inquest, so there wasn't a lot of attention paid by the press, and the jury did not make very extensive recommendations. One of them was that police should use CPR if somebody dies while they're restraining them. Nothing much came out of the inquest recommendations. It's always saddest for us when we seem to be the only ones paying attention. Next slide. Steve Messick died 2013 after he was shot by Hamilton police in a confrontation that was actually in his own backyard. They presumably thought he was trying to break into his house, but it was actually his own house that he was trying to get into after having left a psychiatric unit. This was in Hamilton, Ontario, not where I usually work, but was my hometown. He came towards them holding a shovel, apparently. The psychiatric unit that he'd left recorded him as present and fine for hours following his departure. So the recommendations included that the hospital identify who's actually there and that the police receive training by psychiatric survivors. For services other than the Toronto Police Service, it's harder for us to track whether recommendations are implemented. So I don't actually know whether those recommendations are implemented. I'd hope so. Next slide. Andrew Loku was a case that got a lot of attention in Toronto. He was living in a mental health service housing. He's 45 years old, had 5 children. The police responded to a 911 call where it was claimed that a man with a hammer was threatening. He was described as African. 2 police officers arrived, and within 21 seconds of confronting him, the officer fired, killing him in the hallway of the apartment building where he lived, or the house where he lives. So recommendations we made included training that addresses anti-Black racism. It took some pushing, but we were able to overtly use that language and address anti-Black racism at the inquest. We also got a standing committee added to address anti-racism, as well as maintaining the mental health and addiction related committee. And we required that there be annual publication of data on the use of force with an analysis by race and whether somebody is in crisis. Next slide. Shortly after that, there's an inquest from Michael McIsaac, also in a police service outside of Toronto. He was in a post-seizure epilepsy-related state. He was running down the streets naked, holding the leg of a patio table. One couldn't possibly say that they didn't know he was somebody in crisis. He was shot 12 seconds after the Durham police arrived. In his case, recommendations included an emphasis on better de-escalation techniques for officers, mental health training that would include significant participation from individuals with lived experience in mental health and addiction issues. Bo Baker is an inquest that we were involved with initially. It hasn't actually been held yet. It was also in the town outside of Toronto, in Kitchener. He had called a 911 operator saying that he wanted to kill himself, he had a knife, and that he'd hurt others, including police and paramedics. The officer who shot made an application to the court for a publication ban on his name and identity and to testify anonymously at the inquest. So we were a part of that being heard at Superior Court. And the judgment ruled against that application. The judge saying that there's a high level of public interest in the matter, that the public has a right to scrutinize and comment on the administration of justice at a coroner's inquest, and that this can only be effectively accomplished in the bright light of day, that there's no better disinfectant than bright sunlight. Just as an example of the kind of work that came out of the committee that we were able to get in the Voss inquest, we worked with the Toronto Police Service on developing the Toronto Police Service mental health and addiction strategy. Some of the content is that police officers won't be able to return to frontline duties unless they've shown competence in de-escalation. That training will include strategies to offset and challenge biases. That the service will explore ways to improve based on feedback from individuals who've been on the receiving end of mental health calls, and that the Toronto Police Service will publish an annual report on progress with mental health strategy. You can look at the whole strategy at the link that we provided. I have lost my view of my notes. Sorry, let me figure out how to get back to where I was. Okay, I'm gonna look at my notes another way.
Okay, thank you so much, Jen, for taking us through those slides. And my question to you at this stage is, sorry, are there any other legal proceedings that affect how the police operate?
Sorry, I just found where'd it go? I found it for a minute. Sorry, everybody, for my technical difficulties. Here we go. Okay. So let's finish commenting on the inquest. Thanks, Maya, before answering that question, getting all rattled now. So the Empowerment Council has been quite successful in getting the jury to accept the recommendations that our lawyer has made throughout the inquest and in closing, and that our witness, usually me, has explained to the jury. It helps that we're often the only party there whose only interest is to stop more people from dying. So we're not there trying to avoid getting sued, not gathering information for a lawsuit, we're not protecting our reputation. We talk about what happened and what could happen in a down-to-earth way for the jury. And we make practical observations like the need for sufficient funding for crisis services that people actually want to use, rather than forcing people to use things they don't want, and for the need to check on whether training is actually translating into how police are treating people on the street. So inquest recommendations don't have the force of law, so a lot depends on, so one, how much public outcry an inquest stirs up, and two, whether one of the parties is likely to end up back in court with a witness like us, pointing out that if they'd followed the recommendations from the last inquest, the person would not be dead. So the Toronto Police Service responds to inquest recommendations, especially in cases that get a lot of publicity. Probably the most important recommendations we got were for the creation of these standing bodies that advise the police on mental health and addiction and anti-racism, because we can make ongoing recommendations, including to things that happen in the present time. So in the Mental Health and Addiction Advisory Panel and the Anti-Racism Advisory advocated for demographic information to be kept on the use of force, we stated that there's a need to do a cross-sectional analysis of that deadly intersection of force, being in crisis, and being Black. The data that comes out of that is going to be available in the public portal. Right now, it's still being collected, so it's not been posted yet. And we do that because transparency is what allows for accountability. Also, we know when someone's killed at inquests, but what about the force that we don't see? All the other types of force. So out of the same concern, we have made recommendations at inquests for police to wear body-worn cameras, and they're being implemented so we can see what really happens, although body-worn cameras do have their pluses and minuses. So we're talking about inquests more than anything else today because we understand it's a less known than other means of creating change. It's an important option, but we want to touch on others as well. Okay, Maya, now I'm ready to answer your question.
Okay, so can you tell us, are there any other legal proceedings that affect police, how police operate?
Yes. So there are criminal trials, but we all know that it's rare, but sometimes police are convicted of crimes. So in Toronto, a very well-known incident was when a police officer was convicted of attempted murder for shooting a young man on a streetcar who was in an altered state. It was creative prosecuting in a way because the jury could not be certain whether the police officer had reason to fear for his life initially. So there wasn't a murder conviction, but when he shot another round in the Szigeti when he was already dead, that was found to be attempted murder. Next slide, Maya.
Sorry, Jen, I was not showing the slides, so I'm just going to go back to the slides
That's
now.
okay. That's fine. Slide number 14, we're after now.
Okay. Is this the slide you want?
Yes. So
Okay.
there are lawsuits that sometimes require changes to be made as part of a settlement, but they generally include non-disclosure agreements. There's also, as you can read, a suit that happened that had a number of parties involved. There was the Canadian Civil Liberties Association, the Privacy and Information Office, the Empowerment Council, and the suit was addressing the fact that people who had been in crisis and had encounters with police many years before, in this case, a woman who had been suicidal very long time before, had their information posted to CPIC, which was the Canadian sort of criminal database. That CPIC was then shared with the FBI. The FBI then shared this with American Border Services. So somebody who was trying to cross into the United States and had perhaps been in crisis many, many years before was being prevented from entering the country. So we said this was over the top information sharing and that this is actually health data and shouldn't be shared. So the result was that there's now much more restriction on the type of information that's shared and how it's shared, including with employers. There was a committee that met for many years as well on police records, and it's now restricted the amount of information that's shared with employers as well, because you know people who've experienced difficult times often decide that they want to use that experience to benefit others, but then they were being prevented from doing that when it would emerge when they applied for employment that they had some kind of history of contact with the police. So that's something that very rarely happen anymore. There's also the possibility in Ontario of a human rights tribunal. And there was one hearing that I was involved with as an expert witness where the Peel police handcuffed a 6-year-old black girl's ankles and wrists. The police were found, this is Peel police, they were found to owe damages in that case.
Okay, and what else can people do to make change?
Stepping apart from the law now, we're into public pressure and politics. So the call to defund the police and Black Lives Matter demonstrations got enough public momentum in Toronto for politicians to act. So in Toronto, this resulted in public hearings by the Toronto Police Services Board and the Toronto City Council and its executive committee. And as an example of some change that this enabled, I had previously opposed more money going to police hospital partnerships because survivors had stated from before this police hospital initiative began that what was really wanted was the more non-medical model, so non-coercive crisis services. In Toronto, that's been the Gerstein Center, which has always had more demand than it could meet. But I did not initially get support for this opposition. During the public call to defund the police, though, I was able to successfully get support to stop a recommendation going from the board to the city to ask for more money for the police to do crisis work. And instead, the city put money towards developing alternatives to police and funding community-based crisis services as pilots in certain areas of the city. I put up slide 15, Maya.
I'm at the last slide right now.
So alternatives to police. I'm having trouble reading that slide. Would you mind reading the slide for me, Maya?
Yes, of course. So City of Toronto is funding 3 pilot projects in which 3 areas of Toronto will have enhanced crisis services. Empowerment Council has been advocating for a non-coercive, community-based, no-force alternative to police. Black and Indigenous communities are rightfully highlighted as communities to lead these initiatives. Psychiatric survivors and service users press for recognition as a community whose participation is also vital for meaningful change. And the first change is when people call emergency services when in crisis, they can be transferred to a community-based crisis worker for support if they choose. Do you have anything to add to that, Jen?
Thanks so much, Maya. One thing that perhaps people have noticed who do this kind of work is that as part of the defund police conversation, it can be difficult to prioritize the interests of people who have had direct experience of psychiatric services. And I was very frustrated by this in what I read coming from the city. So I'm going to read to you from the deputation that I gave to the Toronto City Council Executive Committee. So I'm puzzled by the lack of any other specific mention of the community that's most affected in either the summary for the committee or the pilot community crisis support service. Making people invisible, especially when they're the community most affected by this proposal, is discriminatory. So the summary refers to Indigenous and Black communities, which is good, but then it adds and equity deserving communities, which is many people, all of whom are deserving, but not all of whom are equally affected. Why does it not say the community of people with lived experience of mental health and substance use issues? Every crisis call by definition involves someone in crisis, a person who could be judged to have at least a passing mental health issue, yet this community was specifically excluded from mention. If you had services whose every client was a woman, would you rightfully say people who should be involved in delivering and leading these services should be Black, Indigenous, but would you then never mention that they should also be women? Would you lump that under and include other equity deserving groups? Even the Toronto Police Service and Board managed to specify in their materials our community and its importance in their materials. Is there a reason the city chooses to make this community invisible? It's not generic equity deserving community members whose deaths I've had to testify about at a dozen inquests. It's people with mental health histories. So we request the city make a motion changing the generic phrase equity deserving communities to community organizations representing people with mental health and/or substance use issues. In some places, both could be mentioned, and we ask that we also be added to the section specifying Black and Indigenous leadership. I also added that while it's great there are principles of being client-centered, trauma-informed, and reducing harm, you know what service claims to do that? Every service. The service delivery that's so undesirable that people have to be forced into those services will not change unless there's true accountability on an individual and systemic level to the people those services are supposed to serve. Creating a desirable crisis option requires the presence of people with lived experience who have a commitment to the principles of empowerment, human rights, trauma-informed care, and harm reduction. If all that happens with defunding the police and developing alternative crisis services is a reproduction of traditional mental health services that use force and that use it with racial bias, then this project will be a dismal failure. Traditional mental health services also routinely call in the police to handle people in crisis. We need community-based, non-coercive services that are accountable to and inclusive of the people they exist to serve. Crisis support teams are also described with no mention of the essential inclusion in people with lived experience. People with lived experience, this is a term that's commonly used in Canada, by the way, in case you're wondering why it's being repeated so often, have formed community and have self-representing organizations. Most cultures discriminate against people with mental health issues, so inclusion and valuing of culture alone is not sufficient to protect people in crisis from discrimination. Organizational representation also matters. Communities tend to be represented by organizations because ideally the input that's received in this way is broad-based. Every other community is represented accordingly, so we ask that you treat communities equally. The tendency for the voice of people with lived experience to be selected by services is a conflict of interest and unacceptable. Does management choose the union representatives? No, because it's obvious what bias would result. So we congratulate you on the plan to have pilots expanding the availability of alternatives to police as crisis responders. It's a plan whose time has come, or more accurately is overdue, but everything's going to depend on how it's done. And it must be done with the meaningful inclusion of organizations that represent people with lived experience at every level of the pilot. More of the same coercive and racist mental health services is not acceptable. This has to be better. Lives depend on it. As an update, the city has been including psychiatric service user groups in its consultations, which it did do initially, but did not include in its materials, and is now doing better in its materials.
Thank you so much, Jen. And what about the effect of the media?
Sort of the last influence we're going to talk about is that for all the influence that social media now carries, traditional media do still make a difference. For example, without traditional media, I'm not sure that politicians would have been as interested in jumping on board with developing alternatives to police. But educating media in how to talk to and about people with psychiatric histories, that can make a big difference in public and political support for the right solutions. I found that reporters have come a long way since every story that involved someone considered mad also reported whether they were taking medication. I remember a story in the Globe Mail about a man who was set on fire that stated he was schizophrenic and not taking medication, as if medication would maybe have made him fireproof. Now I find that some Canadian media, such as Toronto Star and the Canadian Broadcasting Corporation, do often seek out the survivor voice, and this makes a big difference in who gets paid attention to when the survivor perspective is included. So I'm sure many people attending this webinar have done some amazing work, and feel free to mention it, as well as asking any questions you might have.
Thank you so much, Jen. That was really great. And I stopped sharing the slides, but the last slide that we didn't show had our contact information. So what I'm going to do is I'm going to put our contact information in the chat for anyone who wants it. And at this point, I will call on people who have questions or comments.
So my there are quite a few questions in the Q&A. So there's the chat, but there's the Q&A as well. And there are questions. There are questions there. The first couple of questions, Jennifer, relate to what are the cons of police-worn body cameras? What are some downsides to body-worn cameras when police are in contact with individuals with mental health issues?
Thanks for the question, Arit, I think asked it, and I also want to mention Arit posted in the chat. Shout out to the late great Don White, who tirelessly brought these issues to the attention of the media for more than half a century. And from me too, much love to Don, who was a model of tireless psychiatric survivor activism. We miss him a lot. So the downside of body-worn cameras, it took a lot of consideration for us to support that. One of our concerns is if the police go into somebody's home and they record them at one of the worst moments of their lives, that this be sort of enshrined in police records forever. So one thing we got was that police will turn it off if requested, if they're on a mental health call to a home. However, if it's considered to be sort of a, I don't know how to phrase it, like a criminal call, and then they probably will still leave their body cameras on. But if they're there by request, then they'll turn them off. Some other concerns I've heard raised are that by virtue of the direction it's facing, the body-worn camera only shows the people the police are confronting. They don't show the police themselves. So you see the sort of expressions on the face and behavior of the person they encounter, but not the police. However, the pros are that we see whether police are de-escalating, whether they have been doing it well, what was actually said back and forth, whether efforts were made to talk before, for example, tasers are used. So those are some of the pluses and minuses.
Do you mind if I just comment on this a little bit as well? I mean, clearly there's benefit to body-worn cameras because of the accountability of having the real-time interaction recorded. That being said, as a lawyer is familiar with what happens with windshield or car cams, police car cams. Police are often pretty skilled at making sure all of those cameras are turned off when they're going to do something terrible. They can turn off the body-worn cameras and abuse it that way as well. But on top of which, the sort of systems concern and the argument against body-worn cameras is not the cost of the device, but the cost of the data storage associated with the recordings. And if police are to keep those, forevermore or for a certain period of time, the cost of the data storage is prohibitive in the sense, not that police can't afford it, not that we should care about what it costs them, but we're talking about a huge amount of money, right? So one of the arguments, as I'm sure you're aware, against them is that kind of money would be best put to the kind of community-based peer crisis work, for example, or other support. So it's just a huge amount of money. That do we really want to spend it on technology-related stuff? Anyway.
If I remember correctly, there has been an advance in technology so that this is no longer going to be as prohibitively expensive as it was going to be initially. I can't tell you more than that because I'm not techie. And the police can turn off their cameras, so we don't have to follow them into the bathroom, for example. But it's going to look very bad for them if there's an incident that gets reported and their camera wasn't turned on. So that's a bit of a safeguard. And I also meant to say, nice to see you here, Arit.
So Arit has another comment saying, I wonder if audio recordings would be useful or possible. Do you have any comments on that?
I think it's both. I think it's video, so I think it's audio recorded as well.
But what about audio only, like without video?
Oh, yeah, that wasn't really talked about. I guess because we want to see whether violence is being done.
Okay. And I'll move on now to the next question, which is there discussion and understanding of intersectional communities? So BIPOC individuals with lived experience are likely the most impacted.
There's a lot of crossover now of conversation on with anti-racism activists, including BIPOC members and people with talking about mental health and addiction issues. So we have crossover between the two committees, mental health and addiction and the anti-racism advisory. And there's also other groups that are working together, like the one that I mentioned that's working on Know Your Rights videos. There's quite a lot of attention being paid to that, but I really feel it's been very neglected. Some years ago, we had some experts up talking about changes that could be made to the Toronto Police Service, and I asked them if they had any database on people who are both Black or Indigenous or other BIPOC individuals and who are also in crisis. And they acknowledge the same thing I'd found, which is it's a lot of silos. So there's a lot of studying sort of mental health over here, race over there, and not a lot of the intersection of the two of them, even though obviously the intersection is a really vulnerable point. So I think it's happening finally now, but it's been a long time coming.
Okay, thank you so much. And before I move on to the next question. I see that Kathy Flaherty has her hands up. So Kathy, I'm just gonna, yeah, I just clicked on the option that allows you to speak. So if you have a question, please go ahead. Kathy, you just need to unmute. Okay. So while, so Kathy, if you want like to type in the, oh no, yeah, if you want to type in the chat, or I'll go back to you. But for now, I'll move on to Leah Harris's question, which is, how do you see the 988 process unfolding in Canada? Here in the US, it is deeply lacking survivor and grassroots input.
Yeah, that was the battle that I was describing when talking to the Toronto City Council. I think that the Toronto City staff are really reaching out a lot to be inclusive of the survivor voice, but I'm still like paying attention to what that's going to mean when the alternatives are initiated. We were successful in advocating that right now there is a crisis worker who people can be sent to who call 911. And initially there's some discussion of them being people who work for the Toronto Police Service. And I thought that would be horrible because people's intimate thoughts could end up somehow in police data. So we successfully got that moved over to be independent of the police. There is some issue of transfer though. I don't think 911 can transfer directly. So there has to be some independent content, which doesn't always work, I understand. So I think that one of the issues that you probably found is getting people to be as familiar with the new number as they have been with an old number. We are going to have these pilot services up, and we also hope to have the option that people can call the services directly, as well as calling some kind of centralized number like 988 or 211 or something like that in the Toronto area. But I'd be interested to hear your experiences.
Thank you, Jen. And the next question that I'll go to is, are there advanced psychiatric directives in Canada? And Anita, perhaps I'll direct that to you.
Yeah, okay, thank you. So all of our provinces and territories have different mental health and health legislation. So it's not consistent, as I think yours is nationally across Canada, but in Ontario, we do have, and many of our provinces allow for what you would call advanced directives. I think what you mean is our equivalent is a power of attorney for personal care, where you can leave conditions and instructions about your treatment and specify conditions when you would accept or refuse certain treatment. And those, in that way, you can express your prior capable wishes, and your substitute decision maker is obliged to follow those wishes. You don't have to write them down though. We don't need to have a formal power of attorney document here. You can simply express these wishes. If you don't want ECT, if you don't want antipsychotics, if you don't want to, whatever it is. And at least in theory, this could encompass how you want to be treated or approached when in contact with police and when you're in an extreme state or crisis. So I hope that's responsive to some extent to.
I think the police kind of equivalent of that in Toronto is there's something called the Vulnerable Person Registry, where somebody can describe sort of how to interact and not interact with a person who's considered vulnerable. But I was contacted by an activist who said that she found that she couldn't post it for herself. It was always assumed that somebody else would be posting it about the person, as if they're necessarily incapable of describing their own situation. So she advocated very well on that issue, and I think it has now changed so that people can now choose if they want to post something about themselves should the police ever encounter them. It is entirely voluntary. That was something that we advocated for very strongly. We didn't want people identified to the police who didn't want to be identified.
Okay. And in Canada, do the police departments have crisis intervention teams where an officer is partnered with a social service or mental health worker who ride together during the police patrol shift?
Yeah, there's a million variations of that throughout the country. In Toronto, the way it works is there's a pairing of a hospital worker, a nurse generally, I think always so far, and a police officer. But they're always secondary response. So there has to be a patrol that first goes to the scene and establishes whether or not it's safe for a civilian to appear, which would be the nurse. So they have to go to the scene, and then the dispatch, they contact dispatch contacts the mobile crisis intervention team, and then that team can go unless they're doing something else. So it hasn't been 24 hours, it hasn't been throughout Toronto. That has been an option. However, before that was even formed, the survivor community was asked what they wanted. And what people said is non-medical model, non-coercive crisis services. And that's not what happened, because a police hospital combo wasn't really what people were ideally looking for. But that's what people got. And so it's really just recently that I felt there's been success in really drawing out the idea that what people want is a non-coercive option, because the people who usually call 911 are not the people themselves, or other people. So there should be more places that people who are experiencing crisis feel like they want help from. And that's what we're looking for.
Okay, and I'm just going to actually jump back with a follow-up question on the advanced directives. Has anyone ever successfully avoided neuroleptic treatment with an advanced directive or a request, or by any other means?
Yeah, so these things are pretty durable here. So if there's a clearly expressed prior capable wish against receiving neuroleptic medications, it should be respected by the substitute decision maker. Although I haven't seen it enforced. We have a $25,000 fine in our healthcare consent legislation if a substitute decision maker consents to treatment where there's a prior capable wish against that treatment, or where the substitute decision maker doesn't follow these advanced directives. And doctors are not supposed to accept consent in these circumstances. There are ways to get around that. You can bring applications to suggest that the advanced directive doesn't apply to the current circumstances. So the argument on that side will be, when the person said they would never want neuroleptic treatment, they didn't imagine how extreme their situation would be when it was proposed for them. And if they knew how unwell they were to become, they would now agree to that treatment. But that's the subject of litigation. So the starting point is, if you were capable when you made the directive and you did a personal care power of attorney, and you were clear that you would want to refuse if you became incapable or in every circumstance, and those are wishes that absolutely must be respected. So we do see that. We do see where people have been clear, they will not be treated by these types of medications. I hope that helps.
We did have a related case that went up to the Supreme Court of Canada, the Starson case, that was about somebody's right to refuse treatment. Did you want to mention that at all, Anita?
Yeah. So that the case was, I was appointed amicus curiae, friend of the court, by Canada Supreme Court back in, I think, 2002. And in 2003, in this case called Starson and Swayze, our Supreme Court interpreted our capacity legislation and basically held that the capacity to decide whether you're able to consent or refuse psychiatric treatment is a very low threshold to allow as many people as possible to retain the autonomy to refuse. So in that case, Professor Starson, who's a very bright guy, said he didn't want these meds because they dulled his mind, made him slur his speech, he couldn't do his work. And the court said that those were decisions he was capable to make. So, excuse me, in the wake of that decision, I think we have at least seen somewhat more respect for refusal of psychiatric medications.
And what determines, or who determines, if the advance directive is capable, or that the person was capable when they made the advance directive?
So these are lawyers who make the decisions at the time that the powers of attorney documents are signed. So it's up to me, if I'm assisting someone to make one, to I presume capacity, and I wouldn't question it at the time unless there was some reason to. Sometimes capacity assessors are called in, but once the document is prepared, the lawyer who assisted with preparing it is attesting to the capacity of the person at the time it was made. And if somebody wants to challenge that later on the basis that the person lacked the requisite capacity at the time that they granted the power to others to make the decision, or that when they set out the directive, that's somebody else's problem. So the person who wants to assert incapacity would need to bring an application to our superior courts and then try and prove sort of retroactively, the person was not capacitated at the time. And then a court would decide.
Okay. And so now jumping back to police and crisis work, so can you give an overview of the current non-police pilot programs in Toronto? What's going well and what's not? And they'd be particularly interested to scale programs, recruit staff, and incorporate peers, both in leadership and in services?
Great questions. It's very much a work in progress right now. They're at the stage now of the city put out contracts to sort of tender for people to services to more or less bid on and describe how they do it. We were part of the consultation process that established criteria to look at these agencies for. And one of them is that there be governance with significant participation of the people who are on the receiving end of services, so people on the board, ideally on the staff. And we also didn't want there to be sort of like real workers and then underpaid sort of ghetto of peers that get paid less and have less power and are generally considered less capable than other people, which happens, as we know, sometimes with, well, at least in Canada, I'm sure it does there too, with what's called peer supports. So we wanted people, so there's lots of people who have had experience of crisis who are fully capable of helping people with crisis. So we wanted to be sure that that was kept in mind when they're reviewing the bids for who gets these contracts for expanded crisis services. But it's right now, all we know is that I believe it's one Indigenous group is receiving funding. We don't know about the other areas yet. And we hope that they're following the suggestions that we made for evaluating services. We have had some discussion with the people who are going to be evaluating the services and how that should be done. And one of my requests is that the people who got the funding to do that are part of a large mental health institution. So we asked that they contract with local service user organizations to do the interviews so that people didn't feel like they had to say something good about a service that they might end up back in contact with. They could just speak freely to peers.
And Jen, are you aware, Irita's asking, are you aware of Tina Minkowitz's new book on crisis support? It's called Reimagining Crisis Support.
Oh, no, I haven't. I'd like to see that. Thanks for pointing it
out. Thank you, Irita. And in general, how do you feel about progress made to date and about the future of this work?
How do I feel about it?
Yeah.
Well, it's, progress is achingly slow. And I feel like we have to refight battles a lot. Like there's a while when it looked like we were going to get, like, we did get some funding for expanding Gerstein sort of governed beds, so non-medical, non-coercive safe beds for people, including people who had encounters with police. But then it wasn't really being used, and we had pre-charge diversion as well, where if police encountered somebody they thought might end up in trouble, that they could get in contact with these community agencies and prevent all that from happening. That really didn't get implemented very well either. So there's sort of what's on the books, and then there's what actually happens. So right now I'm feeling that there's a lot of positive intention to develop good alternatives to police. And so I'm, I couldn't do this for so long if I wasn't mindlessly optimistic. So I keep thinking, this is going to be good. This is going to be good. So that's what I'm hoping. But it's not going to be good unless there's significant survivor involvement. It's going to be the same old thing. So stay tuned.
I want to jump in on this as well. And I think, I don't know if we have too many more questions left. Our session's supposed to, I think, go to 3:30. I don't see any more Q&As. If you have any questions for us, please drop them in the Q&A or the chat. But this seems like a good question to sort of talk about a little bit more fleshed out at the end. And so Jennifer wouldn't, and she couldn't say this about herself or her organization, but I've been doing this work almost 30 years. I've been a lawyer 29 years. I had my anniversary, my call to the bar just now. And I think I've been working with Jennifer pretty much throughout, and she's spearheaded now 2 organizations, first the Queen Street Patient Council and now the Empowerment Council. I don't know that any progress with policing our clients would have been made without the Queen Street Patients Council and the Empowerment Council. So the contribution that Jennifer personally has made in organizing all of the things that she's talked to you about today, the conferences, the education, the collaboration, working with race relations advocacy organizations, trying to talk with police. As we all know, it's not easy talking to police, but Jennifer's the police whisperer. She's able to speak in ways that everybody understands are respectful. She's, the epitome of firm but polite, and she never gives ground, but somehow manages not to irritate people in the way that I tend to irritate them right away. And the biggest progress that we've seen, I think, there's many aspects to this discussion. You've heard about them, but the progress that's been made in the transformation of Ontario's coroner system and the open arms with which we're welcome to truly meaningfully participate in the inclusion of the survivor voice in these death inquiries has made a world of a difference, because although the recommendations are not mandatorily enforced, people do, as Jennifer has told you, want to avoid being called on the carpet the next time someone dies for why they didn't implement practical and sensible recommendations. So survivor voice is well represented in a lot of different ways. There's flexibility in the process. You can have Jennifer testify, you can have an expert witness, you contribute, you can just make submissions, or you can aggressively litigate, cross-examine, and probe, be present every day for months and develop that relationship to the jury. So it's just been a very different world. In some of these inquests, we've been invited down to watch the training, to watch the role play. The Empowerment Council has contributed to how role play training literally plays out in the ground, and who is going to play the person in crisis and how. And I think we have made, it's a world of a difference, the way, the language around conversations has changed. But it's a world of a difference from when I first started trying to knock on doors and say that it was important to hear from survivors. I think that there has been a cultural shift so that the expertise, not just the lived experience, but the unique voice and the special expertise that a systemic psychiatric advocacy organization like Narpa or the Empowerment Council brings on a policy level, at the decision-making level from the top down in policing and at every litigation forum, It's been huge. You know, we were routinely, regularly, and summarily dismissed when I first started doing this work. We were always having to appeal things. We were always, you know, screaming from the rooftops. And, you know, to a great degree, that's changed. You know, and they are listening to Jennifer. They are listening to the survivor voice, and they are, you know, appear to appreciate that there is expertise here, and that outcomes will improve if you listen to people who know something about how to de-escalate crisis situations without reaching for your gun and reaching for a weapon. So I've seen tremendous process. Are we there yet? Are we guaranteed zero future police killings? We're definitely not there. But the intersectional lens involving the Black communities, involving different voices, and having these ongoing discussions, the ability to directly participate in the training with police, those things are making a difference. There were periods of time in Toronto. I don't know if it's apparent from the chronology of these inquests, but there were definitely periods of time in Toronto where Black people in crisis were being killed all the time. And I know that you see this in the US, ridiculous, terrifying, infuriating numbers. But we've had periods where, you know, every time we opened a newspaper, someone had been shot and killed by police, usually a young Black man, usually in crisis. We're not seeing that now. And I really think it's attributable to survivor voices, to Jennifer's participation, to the Empowerment Council's relentless advocacy. So I think change can and has been made, but it's a process. But, you know, all credit to, and I don't say this just because she's my client, although like hopefully it helps me in some way. But that's not why I say it. You know, it's just actually the case. So, and I think, given I sit on the board of Narpa, and I see that the same work is being done by Narpa very effectively in different forms. The importance of survivor run rights-based systemic organizational advocacy, in my view, cannot be overstated. And everyone involved with it deserves congratulations and gratitude of all of us who do the legal work and all of the clients. That's what I wanted to say. That was a lot. Sorry, everyone.
Thanks so much, Anita. I'm going to make a little shout out to, in between the Queen Street Patient Council and the Empowerment Council, when I didn't have an independent survivor organization to work for, my late partner and I, along with other great advocates, formed the Mental Health Legal Advocacy Coalition, which intervened in the case that Anita mentioned, the Starson case. And my late partner, Randy Pritchard, was a real touchstone for that kind of work. We miss him.
Randy's organization was focused on people in the forensic system, so people who were NGRI or not criminally responsible, and that there's room for very specific advocacy targeted for that population too. And they too were great. Randy was wonderful. So I see no other questions. We're almost at our sort of appointed end time, and perhaps we should hand it over to our organizers to close us out. I mean, I'm in your hands, but I don't see anything.
I'll just mention for any psychiatric survivor organizations that might be here that it really helps a lot when you can work with lawyers who, you know, get your values, and that that will work sort of independently, because I can't take every day of an inquest apart from my job, and know the kind of things that you want asked and the kind of recommendations that you want made. I've worked with a number of great lawyers, and especially with Anita and now Maya, huge boons to the work that we do.
Thank you.
Thank you so much. Thank you, Maya, Jennifer, and Anita, for your informative discussion today and for your advocacy and work around this critical issue. I'd like to thank everyone for attending today's session, and to Disability Rights North Carolina for hosting this webinar. Today's session has been part of the NARPA 2021 webinar series. The next and final session will be Tuesday, October 19th at 2 p.m. Eastern Standard Time. The unacceptable institutionalization of people with psychiatric disabilities in nursing homes. For more information and to register, visit narpa.org. Thank you for your interest and participation today.
Thank you.